continuation meeting from last couple weeks ago, so I think we'll just follow along with that agenda. We have Mr. McCall, who's a new member of the public that hasn't spoken at a meeting yet, so we thought we'd give him an opportunity to make a statement. And then,
I'll give you a little.
okay, we're good. So, Mr. McCall, if you'd just like to state for the record your address and your name. And we'll give you 4 minutes.
151 Erica Lane, Frank.
We'll give you 4 minutes to address the board.
All right. Well, I had been hearing about the ordinance, and then I've just been getting bits and pieces, and I was missing the papers and not getting to read what was being put in there. And I was just wanting to know what's being considered. Mr. Shields needs the commissioners meeting about nuisance and all of that, nuisance and annoyance. I kind of want to know just exactly how that fell in there, and then the times it would be enforced, and kind of what would be considered. Because Kim and I both we're avid shooters, and we have good backstops, and occasionally we like to test loads and stuff like that. So I was wondering your times, if that was going to affect the shooting and stuff like that. Then also my daughter's been a drum major in the band for the last 2 years, and I was wondering if we're with the band a lot, if the ordinance would affect the band in any way. As their practices start. Start early, sometimes end right about dark. Then they come in from competitions, and that can be anywhere from 11 o'clock at night to 2 or 3 in the morning. Or they leave going to a competition about 5:30 or 6, depending on where they're going to. If that would affect them. The biggest parts of it.
Okay. I'm sorry you missed so much of the conversation because a lot of this has been discussed.
I apologize for that. I'm getting in on the tail end.
I understand. I think Matt's given you what is the latest draft copy of an ordinance that he's produced with the help of the county attorney, Mr. Jones.
So let me just clarification. The only ordinance that has actually been drafted is one by Matt. What I have done is I have taken his draft and I have made some marks, I think primarily for discussion. Not essential that everything that I have addressed be changed, but Matt and I actually this afternoon had a chance to speak with him about some of my comments and where we go from here. But to say that what I produced for Matt is a draft would be incorrect. It's not a draft.
Okay. So, the band, do they typically practice in town?
Yes, it's high school.
Okay, so that wouldn't apply. This is just for the county, so anything in town.
Basically everything outside the city limits.
Okay.
For Franklin and Highlands. Is Erica Lane in the city limits?
No. Okay. No, it's not. Then my father is up on the Highland Road, 7316 Highland Road, right where Long Creek comes out. I have some property under there also.
And then if you
But
will,
the main one is Erica Lane.
we'll talk about the whole thing, but the exemption, it does talk about gunfire only. It's one of the exemptions.
So if there's nothing else. Chester, if you could kind of go through, everyone's had a chance to review Matt's because we sent it out last week.
Okay, good.
And so everyone hopefully has come with revisions or thoughts or comments related to Matt's draft.
Yeah, let me, and much of what Matt has done, the changes that I have made, really I think were designed to perhaps maybe make things a little shorter and perhaps maybe a little more understandable, but I don't think there's any fundamental know that I have any fundamental objections to the ordinance as he drafted it. A lot of it is purely and simply trying to get things more simplified and making sure that we don't define something in a given way in one place and then suggest that there's a different definition for it in another place. And I think we've got to be real careful about that because the whole ordinance hinges on the definition of loud, unnecessary, and disturbing noise. I think that definition needs to be thought about with each provision that is put in this ordinance. So with that having been said, I think we can, I think the change that I proposed from 160.02 is self-explanatory. What I wanted to do was tie the ordinance in. Basically what you have is a nuisance ordinance, and the way you're defining nuisance is to basically be a nuisance is a product of loud, unnecessary, and disturbing noise. The comment on 160.03 is self-explanatory. We're just shortening the reference for statutes. We do need to add to my comment a reference to 163A-133. Jurisdiction, I think that comment is self-explanatory. I think where we get into a little bit of substance is under 160.05, the definition section. When I read what Matt had prepared, he defined loud, unnecessary, and disturbing noise, and then he also defined unnecessary. The more I think about 160.05, I would probably combine A and B. You'll notice that I picked up language that's underlined in A from a later place in Matt's ordinance. Basically what I did is I took that language, lifted it from a later appearance of the ordinance, and plugged it into the definition because it's clear that language has to do with the definition of loud, unnecessary, and disturbing noise. And what I would think might be appropriate is to combine the definitions in A and B to make it clear that the loud, unnecessary, and disturbing noise basically be something that's occurring between the hours of 11 p.m. and 7 a.m. and which has no business or economic purpose. I think that was the essence of what Matt was trying to get communicated there. With that having been said, I think that would make a good definition with the remaining language that Matt had put together for loud, unnecessary, and disturbing noise. And then I think under 160.06, I keep the loud noise back to constituting a nuisance and will be deemed a nuisance. And we're just simply, I think all you got to say is that you're basically deeming loud, unnecessary, and disturbing noise as defined in this ordinance as a nuisance. And I think that's all you got to say. I think to say more, you end up possibly making it more complicated. Going to page 2 at the top where it talks about some things to be considered. If we look at each of those items, virtually every one of those are items that are actually referenced in the definition of, the term again, loud, unnecessary, disturbing noise. So my thought would be, let's just eliminate that. Go back to the definition. What does the definition say? Loud, unnecessary, and disturbing noise. What does it say it is? When you look at that definition, instead of having to look several different places for where that problem is. If you've got things you want to add to that definition, you can certainly do that. But let's look at one place to determine what a loud, unnecessary, and disturbing noise is. Now, the section talking about that basically are some examples. I drew through that, and primarily the reason I did was not that I'm against setting forth some examples. In fact, I think examples of violations of this statute would be really, really a good idea. But I think what I suggested to Matt that we do is we look at what are the specific complaints that we receive in this county that we, or this planning board is trying to address, and let's make sure we get those specified here. The actual problems that you're dealing with, let's get those specified here, and let's make sure that the way those are written, that they tie in well and pick up all of the elements of what a loud, unnecessary and disturbing noise is. Because you can't in one place say that the following is a loud, unnecessary, disturbing noise, and then in a later part of the ordinance say it is that without it being in accordance with the way it's defined. It's going to have to pick up every one of those elements that's in that definition. So the idea of enumerating examples is good. I think my best advice to this board would be to pick up the very specific things that you are trying to address, with the understanding you're not trying to make an exhaustive list of things that would be regulated by this statute, but instead giving some examples of specifically some things that you know are intended to be regulated by this. Now, going back to 160.06, and this is something I just want you to think about. It's not a question of right or wrong, but it's something that you need to think about. The word willfully is used. It says it shall be unlawful and shall constitute a nuisance for any person or a group of persons, regardless of number, to willfully make, continue, or cause to be made, or continue any loud, unnecessary, and or disturbing noise as defined herein. All I'm saying is use that word willfully with your eyes wide open, knowing what it means and knowing what potential problems it could present to a prosecutor in trying to enforce this ordinance. There are a lot of cases where it's real clear that somebody is doing something willfully. In fact, they may be yelling at you, I'm doing this on purpose. I'm doing this to make you mad. But there are many cases where things are being done willfully, and there's not a lot of objective evidence to show that it's being done willfully. The end result, the fact that it's being done willfully, is certainly one thing that you probably are concerned about in this regulation. But I would submit probably the bigger thing is dealing with an obnoxious noise perhaps in the middle of the night, whether it's being done willfully or not. I mean, what about, for example, the situation somebody's having a party, maybe you've had a little too much to drink, it got too loud, and it stayed too loud. And the person said, I'm sorry, I didn't know it got too loud. Is that going to help the neighbor if they keep on doing it? I mean, if they kept it going for an hour, 2 hours, I don't know. I submit to you, though, proving somebody's state of mind, what they intend or did not intend, can be a difficult thing to prove. And you may want to look towards a more objective standard. It's not a question of right or wrong. It's just purely and simply you're adding an element to proving an offense or a violation of this ordinance by having to prove that somebody did something willfully as opposed to some other reason for it being done.
How does removing the word willfully impact?
I think you can draw this to where it is ultimately a function of whether or not the loud, unnecessary, and whether a particular problem is a loud, unnecessary and disturbing noise as defined without regard to whether they are willfully making that noise. I guess it was my thought. Now, there might be some would say, no, we don't want to regulate that. We only want to do it when we know for sure that they're doing it with ill intent. And that's fine. You can certainly approach it that way. All I'm saying to you is when you do, there's going to be some people acquitted that you may not feel need to be acquitted because of the willful intent requirement and being able to prove that. Getting into somebody's head and saying they did this willfully. And it'd be one element that would have to be proven by proof beyond a reasonable doubt.
If willful were used as part of the group, such as which result from loud, unnecessary, willful, and disturbing noise, it seems like would that still, do you think, make it harder to enforce, or is that giving a way to put that willful in there?
If you're worried about proving someone's state of mind as being something that may be difficult, I would take the term willfully out. On the other hand, that having been said, it may be that you're less concerned with, say, for example, accidental noises, and more concerned with just willful noises.
We talked about calling it a malicious noise, because focusing on intentional harassment, not exclusively, but focusing on that.
The intentional seems to be a bigger issue right now in the county than anything else, which you probably know more about than the
Well, the willful or intentional, is certainly one step in the right direction. There's no question about it to regulate that, and it's not necessary to change that language. All I'm simply saying to you is you may potentially have a situation where that willfulness thing is used to basically defend somebody from violating this ordinance and what was intended by this ordinance.
From a legal perspective, I guess we spend a lot of legal perspective. I think it's from your perspective of legal view, I guess. We spend a lot of time talking about malicious, meaning the guy, play the music property line, his house 100 yards away was pointing speed towards his neighbor's 6 feet away. Is there some reason malicious is not as good a word maybe as we thought it was a couple of weeks ago?
Actually, I think malicious and willful are really pretty similar. They both require you to kind of get inside somebody's head and figure out what's going on with them and proving it by proof beyond a reasonable doubt. And that, I guess, is sort of a fundamental question that you have to ask yourself as this planning board is, are you looking to regulate the end result, the offensive noise, or the heart of man or woman, as the case may be, or both?
When Sheriff Hall was here the other day, if he didn't send you a warning, then if he was called back, that would be the willing part or the malicious part at the law enforcement. Was that what his gesture was? That kind of the first time he has to respond to be a warning to the people, then if they have to come back, hey, you moved it to another level and to the willing part or the malicious part.
I just talked to the sheriff a few minutes ago, and that's exactly right. He said to be sure that you express my opinion on that, I would like the first step as a warning the second time. And he's all for this malicious, and he also said the nighttime. He said, because it's hard to tell somebody that works at different hours of the day or night that how do you tell somebody that they're in the daytime that they're acting maliciously?
We said economic activities.
Well, no, I'm just talking, not work-wise. I mean, people that work and they're at home sleeping during the day or they're whatever, the people, so it's hard to...
And I believe he was okay with that 11 to 7.
He was fine.
That you left in there, that you talked
But I'd ask him what my question for the sheriff was this disturbing the peace of North Carolina and the malicious disturbance. And both of those two are real close to being the same, with the exception of, or disorderly conduct, I'm sorry. That disorderly conduct, people may not know that they're doing it intended to offend somebody, whereas malicious they are.
So, how would, is there a definition difference between malicious and willfully?
Yeah, I think there is.
Court?
I think there is. I mean, you can do something willfully without having a malicious bone in your body. But if you do something maliciously, you have to have ill intent, and you also have to be willful.
So would malicious be hard to prove?
I think malicious probably would be harder to prove. And Gary's point, I think, is extremely well taken. If the way you anticipate this ordinance being addressed is for law enforcement to go out there and say, hey, you're violating this ordinance, and I'm giving you a warning, then, whether you have willfulness in it or not, or the requirement of willfulness or not, he goes back out there. I think the prosecutor, any prosecutor worth their salt, can make a pretty good argument that there's willful, that things are being done willfully there if they've been warned, and then they continue to do it. In other words, it's not an accident at that point. They're alert to the fact that there's a problem, and they're continuing to down that path. So I guess my thought would be is if you contemplate there being a warning first, then perhaps maybe the best way to approach that is to address it in enforcement, as an enforcement, that a warning would be provided first, and if the conduct or similar conduct continues, then at that point in time, citation can be issued. Well, I don't even know that I'd necessarily call it willful.
And also, he said that it should be addressed as at the discretion of the officer sits on scene.
I believe it's what he told the whole committee the
Yeah.
other day. Discretion of the officer is going to be very important for us.
Yeah, I think that's implied in any criminal offenses, that the officer use some discretion as to whether or not there's been a violation or not. And especially, I think, if you're directing that there be a warning mechanism, those seem to go hand in hand.
But they could provide a warning even if one wasn't in. Even if this didn't prescribe a warning,
Yeah, I think
they
it
could
can.
still prescribe a warning.
I think it can. If there's worry, though, about people being prosecuted for accidentally making a noise, then the warning system, I think, is a good way to address that concern.
If we leave the word willfully in there, that might keep you from calling NFB has 3 parties a year at her house and it disturbs you. That might keep you well. I wouldn't think that would hold much ground. She prosecuted in April and September and December. She had a party that she being too loud, as opposed to she had one 3 nights a week. And you called it. I think that keeps some folks from pestering the sheriff's department, having to go out on every call and protect Peggy or whoever, that you wouldn't be harassed every time you did make accidental noise or slight disturbance, because it wasn't willful.
Would you foresee a legal problem with having a malicious noise ordinance that was specifically targeted people that did it in malice?
A legal problem, I don't know. there's nothing legally to prevent you from doing it that way.
I mean.
But again, from a prosecuting standpoint, if you've ever been to criminal court, you'll hear some of the dangest excuses you've ever heard in your life to negate the mens rea requirement or the state of mind requirement for giving anything from my dog ate my homework to whatever else. You'll hear a lot of things that are just almost you wonder whether there's truth to those excuses.
Well, knowing some of the cases that we've been presented with,
Yeah.
do you think that it would be hard to prove those were malicious?
With the one where you had the fella crank up his stereo, put the speakers at the edge of his lot line, turned it up as loud as he could, and left for a half a dozen days or whatever the facts were. That one, I think I can prove that. And I don't do criminal law.
Or the one where the sheriff was having to come out when they were beating on the side of their trailer and making noises in the middle of the night.
They were running their backs off.
But let's just fast forward and just do a hypothetical. What about 3 or 4 friends got together, hadn't seen each other since college days? It's 20 years later. Fast forward 20 years, they have them a few beers, and there's nothing going on with them malicious, but they just got loud. They started thumping on the side of the trailer, and they irritated their neighbor.
With most of those people, the sheriff sends somebody out there, and they're going to quiet it down, and they're going to say, sorry, laws, and that'll be the end of that.
But it's when they continue that. I mean, we've had cases where, heard about where the sheriff goes out, tells them to get quiet, but as soon as the sheriff leaves, they actually turn it up.
Yeah.
So, but it's seen as malicious.
Well, that's actually, like me personally, the one that you described, guys come back together and get a little rowdy, those are the people that I want to protect. Those are the items that I do not want this to happen.
Well, and if that's the case, if you don't want to set an objective standard of what is acceptable and not acceptable conduct, then using the term malicious or willful is probably a good thing.
And I think the idea is that these people would respond to the warning, and if they didn't, then it steps into
Then it's
willful.
I mean, I think that's what we were asked to address with some of these problems that are, there's 10 of them in the whole county, just to give Robbie a tool so they can solve these problems for these people. Obviously, have not in their position.
Yeah, and you get into line drawing is the problem. The guy's having 2 or 3 beers. That was pretty sympathetic. That's pretty sympathetic. What if they had 2 or 3 cases?
Well, if they hush when they're given a warning, then
Well, if you had 2 or 3 cases of beer, you may or may not be able
Then you get
to
fined.
listen to that. But you might not, and you might also not have the ability to create the willful intent.
That's why
Because
we
my
have
smart cars, kind of deal with that, so I'm not driving around drunk, and I don't really understand the process for it. But I'm nevertheless putting everybody else at risk. I mean, somehow you got to deal with that, I think.
Well, and that is the way you do it.
The law says.
You don't see any DUI laws say they willfully intend to drive around drunk. Do they?
No.
You don't, or that you do it maliciously. I mean, it's designed to deal with the problem of people driving drunk.
whether they do it or not.
Would that one-time warning not cover those
Yes.
one-time partiers? Now, if I carried on for a full week like that, or I got out the yard and target practice 7 days for a week, and harassed the neighbors, and they called out more than once, but would that one time not cover?
I think if you have a warning system in there, you're gonna solve a lot of what I'm hearing is concern about innocent or maybe minor neglectful type situations where people just didn't know. I mean, you know, it happens sometimes. I've been in a condominium one time where somebody was talking too loud, and they didn't realize they were talking too loud, and they bothered the next door neighbor. And they were talking so loud, and when they had a call to their attention, they quieted down, and that was it. You know, so.
May I ask about the definition of unnecessary, where you have without any business or economic purpose? How does that apply then in a situation like obviously this party that we're being somewhat forgiving about has no business or economic purpose? A lot of domestic noise has no business or economic purpose. So that definition of unnecessary, I think it just worries me a little bit. We're then shooting.
Actually, what I think is what they were, I think the intent of that language, and you correct me if I'm wrong, is to take out of the definition of a loud or unnecessary disturbing noise as being something that is a natural byproduct of a lawful economic or business purpose. In other words, if you got, for example, a situation, well, I don't know that you're going to necessarily have this between the hours of 11 and 7, but say, for example, you had somebody who's putting up hay, maybe.
Well, my neighbor loves to.
You understand what I'm saying? And I guess that's a judgment call, you know, as to what sorts of noises should or shouldn't be regulated. I think obviously a case can be made that we as a society are probably a little more tolerant of people making some noise if it's to serve a constructive purpose of, you know, pursuing economic or a business or something like that, that's a lawful enterprise.
Loud, unnecessary, or disturbing noise rather than, because certainly we're not trying to make all unnecessary noises considered a nuisance, is what I'm trying to say.
So if I go out at 12 o'clock at night and call a dog in every night at 12 o'clock, somebody may not like it, but it is unnecessary just to get the dog. And I would be in violation of this ordinance.
Well, and also if the dog's barking, you're going to be in violation too, because is there somewhere in this right here that it's excluding dogs?
I think by definition of the violation, if you look at 160.06, it says that in order to have a violation of this must be, it says any person or group of persons, regardless of number, to willfully make, continue, or cause to be made or continue any loud, unnecessary, and disturbing noise. Dogs are making the noise, not the people. Now, on the other hand, I asked this question to Matt, what about the situation where you've got, say, a man or a woman poking a dog and making it, that's another story.
Well, I still think that would fall under malicious. If they were intentionally doing that to those dogs with intent to disturb the neighbor over there, it still seems, I mean, to me, it seems like it's a malicious act.
I think the dog stuff, though, has to go under animal control. I think that has to go under a separate document.
If you're creating noise, malicious.
You're not, the dog is.
If you were poking the dog, wouldn't that go under 106 here?
Yeah, I think
for calls to be made?
I think you can make the case that
I want to go back just for a minute to the definition of unnecessary without any business or economic purpose. Just wanting to make sure that it just seems to me that we should have loud, unnecessary or disturbing noise, because otherwise any personal noise that is not for an economic activity could be considered as unnecessary. So your good old boys having a reunion, that's not necessary, and therefore they would fall under, as a nuisance.
What I would recommend is that you eliminate B altogether, and I would simply add some of that language to A, and just simply say that loud, unnecessary, disturbing noise shall mean what's written under A, and which has no business or economic purpose.
So and, not or.
I think I would use, because again, what we're defining is not loud noise, unnecessary noise, or disturbing noise. What we're defining is loud, unnecessary, and disturbing noise.
You had mentioned the example, which is relative to, well, F2
Yes.
was the example that we've heard multiple times.
Yes.
You had struck that from,
When I strike that there, what I really mean to say is we need to discuss and move on. Have no problems at all with examples, and I think, in fact, I think it's a great idea if you've got some specific things that have happened that you know you want regulated, give those as examples. But what I want to do is I want to make sure they're written in such a way that it's clear that those particular things meet the definition of loud, unnecessary, and disturbing noise. And it's not carving out a different standard. Does that make sense? You got to be careful, or otherwise, before you know it, you've got a half a dozen different things you're having to look at when you've only regulated one thing, loud. And I mean, if, for example, one of these things specifies conduct, but it doesn't meet your definition of loud, unnecessary, disturbing noise, guess what? It says it's a violation here, but it's not outlawed, because the only thing that's outlawed are defined loud, unnecessary, disturbing noises. Okay?
Do you not think, do you recommend striking the 5 things that help determine whether it's loud, unnecessary, and disturbing? And yet it seems that those may give a clearer picture.
Well, let's go back and look at the definition. All right, time of day. What's addressed in the definition? 11 to 7. So we already got it.
All right.
Proximity to neighborhood residential structures. What's in the definition that addresses that? It's got to be loud enough to be heard from an occupied residential unit. So I think most of those things are addressed already in your definition. Then the question becomes, if you've got that in there with the directive of shall be considered, it's almost like you're adding to the definition of a loud, unnecessary, disturbing noise.
How about the idea of it being recurrent? That was one point that seemed important to us, is that it's not something that's happened one time.
And I guess, yeah, and I guess my thought is again, the definition says any noise because of its volume, level, duration, and or character or noise.
Okay, so that will be okay.
Where, question about, say, a group of 20 in the morning to go riding across the mountains, where does that fall into the noise ordinance? Are they protected, or are they going to be, get out of here?
I suspect they'll be in the next county before the sheriff gets out
Yeah,
there.
the duration.
I guess one.
Well, no, I mean, if they're here for a week, and every morning at 3 or 4 o'clock, they all get out there and they crank.
They may be
Hardly
coming
don't
in
warm
3 or
up
4.
just in a blink of an eye. Okay, so they're going to sit there and they're going to let their motorcycles warm up for 10, 15 minutes. I do. So therefore, everybody around is being disturbed at 5 o'clock, 6 o'clock in the morning. That's my concern with a noise ordinance, because a lot of stuff that a lot of us do will not be protected. Malicious, we've heard from all these people in coming in here with the complaint. Their neighbor is directing a noise so they can't sleep at night, and that's what we were asked to do, I think. And to me, I'm all in favor of a malicious noise ordinance. If that is something we can draft that will protect these people from being disturbed at night because the neighbor is intentionally causing them noise, I'm all in favor of it. But as far as somebody telling me, and it happened to me in Highlands before noise ordinance ever came about, a new person moved into the neighborhood and started immediately complaining about things we've done for years, and it took our right of way because that's what caused the noise ordinance to come into play. I think we were asked to do a malicious focus on malicious acts of certain people in this county. And to me, this noise ordinance right here is including a lot of stuff that's going to take a lot of rights away from Macon County citizens.
I think the board's trying to find the best way to write a malicious type ordinance. I think all the questions that have been asked have been directed at that intent of malicious. being
Right,
worded
but there's
and
nothing
used.
in this ordinance that says
So,
malicious.
As a group, we've tried to write that. Do you have an ordinance you'd like to bring to the board to share that addresses
Well,
all the malicious issues?
I thought Bill handed one out last meeting.
And we've discussed that and tried to incorporate those ideas and those thoughts
Right.
in this document.
Right, but it's not, there's
So-
nothing in this that says anything about malicious. And malicious is a simple, straightforward ordinance that says anyone who intentionally makes noise to cause harm to their neighbor is a malicious act.
We've
And-
discussed that word more than once here today. So
I
we're
understand.
trying to get there, John.
Okay, well, I just said that I mean,
That's the purpose of this.
Well, I think the problem with using the term malicious is that people who are malicious can very easily adapt their conduct in such a way that it does not appear to be malicious. And therein lies the problem for a prosecutor trying to deal with a situation where we're pretty sure it's malicious, but we can't actually prove that it's malicious.
What you were saying earlier, if you made it malicious intent and it was a sole purpose, it sounds like we'd be opening up to.
You're not going to have many prosecutions.
Yeah, you're going to have good attorneys will get a hold of it and find some loopholes and say, well, it wasn't malicious because he was doing this and this. And the next thing you know, we spend all this time making a noise ordinance, or nuisance, malicious noise ordinance, that is a sense nuisance. And then stuff just keeps getting thrown out, prosecution.
Those are the points and counterpoints,
Okay,
Stephanie.
right, and
Yeah.
well, go ahead.
And then we're still back to square one, just have the same problem.
Okay, and that's true, and that's where I go back to we're taking a civil matter into a criminal matter.
If we included willful in the definition on purpose, if we have willful, loud, unnecessary, and disturbing, and we have a warning system as part of this, then once again, once they receive a warning, if they continue, then it's easy enough to show willfulness.
I think you've got certainly a much better case as a prosecutor. If I were a prosecutor, I would prefer that over the term malicious. Now, there's plenty of things that are tied to malicious intent. There's no question about that. There's nothing to prevent you from doing it that way. All I'm saying is people, being what they are, they're creative and they're resourceful. And the fellow that doesn't mind taking his speakers and putting them on the corner of his lot, blasting it up full volume, and leaving for a half a dozen days. When he hears that he could be prosecuted for maliciousness, he's going to be more creative. He's going to be more resourceful in how he irritates his neighbors the next time.
Put this thing on a timer and turn it on at 7 in the morning and off at 11 at night.
Exactly.
So that's what worries me about the time issue. What we spend a lot of time talking about the maliciousness of it. And I think, probably some of these people are not, they'll be creative, but not in a constructive manner.
Exactly.
So, I mean, what do you suggest there? I mean,
Well, Matt and I actually talked a little bit about that as well, actually. I mean, on the one hand, among reasonable people,
we wouldn't be.
We could probably sit here and agree that, 11 to 7 or 12 to 6 is a time where everybody ought to be able to get a little rest. We could probably all agree on that. And so none of us are as offended by the possibility of regulating noise during those hours. But on the flip side of it, I think Matt raised the point. I said, well, what about this window of time? Are you okay with that? And he started thinking, and he said, we may, by trying to be really reasonable with this ordinance, we may be making a monster. Somebody saying, well, I can't get them between 11 and 7, but boy, I can sure crank it up at 7:01 and run it till 10:59.
We had that discussion last time. I think the board generally felt that the really malicious noise was a problem at any time. And then really the only reason why we were going toward the hours that we were was because the sheriff had expressed so strongly that that's what he preferred. While we were all thinking, but malicious is malicious.
The people we've heard from, I can't help, the people we've heard from, the stories we've heard from the sheriff and these other people, I can't help but think these people are intent on causing their neighbors stress, and I think we just...
Or either it's reckless disregard, one of the two. And either one of those is... we as people, the law says we've got to put up with some inconvenience from other people.
Right, but the example, that's the worst one I've heard about the guy with the speakers on the property line and all that. That's not the sort of inconvenience I think people expect.
I agree. It would surprise me if you got a great amount of disagreement on that case. That just doesn't strike me as being one.
Did you see this that was handed out at the last meeting? You brought this in, did you not?
No, I did.
This malicious ordinance?
No, I hadn't seen that.
That was handed out at the last meeting.
Okay.
And that's something that really got our attention on focus on malicious. Even though the county commissioners did they not ask us to focus on malicious acts? Is that not what they?
I think that may have been some of the wording that was used. I think the problem becomes in the legality of the word malicious.
I think what they wanted to avoid is situation of somebody getting in trouble over, say, legitimate economic activity. I don't think they intended for people who may have accidentally irritated somebody that could be corrected, being prosecuted, or being in violation of law.
I think Kevin said something about nuisance.
Yeah, I think he basically, and really that's all, ultimately it comes down to semantics to some degree, but, I was just taking a quick glance at this. When you define malicious noise as a certain thing, you don't have to get hung up so much on whether somebody did something maliciously or not. You just simply say if they made malicious noise as defined by this. So if you like that word malicious, that may be a way to be able to use it, is by defining what malicious noise is.
But I also liked your use of willful. Maybe it could be malicious and willful, because the willful would be if they received a warning and then they continued with it. It could be willful, but still not malicious. So it seems like using willful as well as malicious would be beneficial.
Do you, just in glancing over this, do you not think that this ordinance right here, just by you looking at it just briefly, would be a step in the right direction before we go into a full-blown
I haven't looked at it, but what I would say is I think any steps that are not too broad, but broad enough to address these examples that keep coming up, I think would be a good thing.
And that's why that I say I'm in favor, because those people need protection. But I think there's 35,000 other county residents out here, we not, or whoever, how many there are in the county, we don't have really issues. So their complaint is what, in my opinion, a malicious act. And so if the sheriff had a tool, which is pretty well simple and straightforward in my opinion, that he can go to these people and say, look, see this? This is going to get you fined the next time I come over here. This is your warning. And so the sheriff leaves. If those people that complain have a problem, they call back in. And also, I think it was mentioned before, that there should be more than one neighbor complaining about this noise. Because it falls into the unreasonable or
Maybe there is just one.
I think that's the tricky part is it's not any less offensive if you've got a situation where there's only one neighbor.
Yeah, I think we need to stay away from the one neighbor angle. I'm not sure there's but one neighbor involved in that.
well,
I've heard that story about on the speakers and all that.
I hear loud and clear your concerns of taking this thing too far. And I think that's something that this board would be wise to consider as it puts together a recommendation for the Board of Commissioners, because I don't think they want to go too far.
right.
I really don't. I think they want to try to address real problems.
That's right. And that's what those people complaining about every time. And this man here is concerned that we're going to take his rights away to shoot his gun.
Well, it's clear we're not trying to do
Right,
that.
I understand that, but
So, Mr. Jones, you've heard this board now more than once, and you've read this document. Are we?
I think
Is this
you're
document
getting
the
much
intent of this
closer.
board?
I think you're getting much closer. I don't know what the breakdown of this board is. Not everybody on this board feels the same. I do sense that. I think you got some that might be willing to regulate a little bit more, and some would prefer to see regulated a little bit less. I don't think y'all are all of one mind on what should or shouldn't be regulated. Now, I may be wrong on that. I'm just kind of telling you my reading of the pulse. But y'all will have to speak as to, as a board when you make a recommendation. The question is are you in the right neighborhood? Yes, I think you're in the right neighborhood. We're not. The question is, it still needs to be fine-tuned a little bit. And it may well be that what you need to decide is, do you want an objective standard or a more objective standard that doesn't require determining that something was done willfully or maliciously by the fact finder to define what is a nuisance? Or do you want those requirements of proving the state of mind, the maliciousness or the willfulness, to be a part of the offense? I'm not sure you've got complete agreement on this board about that. You can have noise that is clearly offensive and a problem probably to everybody in here, and you can regulate that without inquiring into state of mind. But what I'm hearing is there's some that would say, notwithstanding that, as a safety to make sure we're not going too far with this, we want to attach that requirement of either maliciousness or willfulness to the violation to basically protect somebody who may have just been making noise neglectfully or maybe recklessly.
I think we just want something that allows the sheriff's department to be able to go out and handle it.
yeah, exactly.
I think that's what we're trying to do.
Yeah, I think that's the vehicle. The question is just exactly. But I mean, if there's consensus on this board that the mission of this planning board is to bring back an ordinance that requires an affirmative showing that somebody did something willfully or maliciously. If you understand that that is your marching order from the commissioners, that it be done that way, then that's the way it should be done.
And if we were to incorporate a warning system, is there ever a case when people may, let's say we have a warning system, the sheriff goes out, tells them to be quiet. If they don't be quiet, is there ever a time when you wouldn't consider that willful or wouldn't consider that an offense that should be followed through on? Or does that warning system give us that protection if we're not going to be excessive in application?
You're going to get arguments on it in court, I promise you.
That even if they go
The
out.
argument from the prosecutor will be, look, there's not an issue about willfulness. The person was told that they were too loud, and then they continued right on. Okay? And the flip side of it was, the flip side argument would be, well, that's what the sheriff said. He said I was too loud, but I disagreed with him. We weren't too loud. And we continued right on doing what we were doing.
If the citizen calls 2 times in 3 hours, then that's one thing. If they don't call again for 9 months, I think that's another as far as how you would.
This kind of seemed to me that if the sheriff gave a warning and they continued, that would show willful. But you're saying it doesn't necessarily, if they disagree that it was a problem to start
Well,
with.
And that's what law cases are made of in court, unfortunately. The hair that's been split gets split half a dozen more times.
So, Ms. Susan, what did you think of this ordinance right here that Bill handed out the last time? So if it said Macon County malicious noise control ordinance, what if it said Macon County willfully, maliciously noise control ordinance? And change a few,
Well, it's just that some of the things that Mr. Jones has said have made it seem less. I wanted to get a legal opinion on how much static would that cause to try to use those terms. And he seems to be saying, yeah, there's a problem.
I don't mean to signal that it's wrong to use the term malicious or willful. All I want to do is point out and make sure this board is clear that that is an element of the offense that a prosecutor must prove. When it says something, it's not a fact that there was so much noise that somebody was being driven crazy by it. That's part of it, but you have to show that all that noise that's driving somebody crazy, it was being done willfully.
Is it not equally hard to show that the noise was so excessive that it would cause a normal person stress?
It could be in some cases. On the one hand, I mean, in that situation where you got one neighbor, and only one neighbor, it's going to be a swearing contest between the person making the noise and the person that's hearing it and can't sleep.
And perhaps the sheriff would check out.
Yeah, he may or may not have heard it.
Well,
Yeah,
I'm not married to any of these words to the county service.
Yeah, and I don't mean to indicate that by using the term willful or malicious that it's not enforceable. I'm just simply saying that you're delivering some difficulty for a prosecutor in prosecuting a case that's hard to prosecute in the first place.
So it sounds like if you use the term malicious or willfully, that you might not have the teeth per se that you need to get the job done. It's in court.
My concern is that. I mean, for example, I've read an article that's on a situation going on over in Jackson County as we speak. There's apparently a little bar over there that they have bands and whatnot, and they play in the after hours a little bit. And is the bar or anybody there in the bar maliciously keeping the neighbors that are close by awake? No, they're not. But if it, and I'm not saying these are the facts, but what if that went on, loud music and partying and loudness, you know, outside tables or whatnot, I don't know what the facts are in this case, but say it went to 2 or 3 o'clock in the morning. No, I don't think any of those people are necessarily willfully or maliciously trying to cause anybody, but the fact is, there's discomfort if you've got 20 houses right next to that little pub that were there long before that pub was there.
Well, if in our definition that willful included having received a warning and that the noise is not abated. Could that be considered willful if the noise was not abated after the warning?
I think we could, through definition, make it do that, yes.
Would that solve the problem to some extent?
It might possibly, yes. That's what I was saying, a system that incorporated a warning might address that.
And then not responding to the warning, therefore it became.
Y'all mind just give me a show of hands then to tell me if you had a sheriff go out there and warn before any kind of citation was issued, whether that gives you the comfort that you're looking for? Or do you want more?
I guess I was operating on something the sheriff had that authority.
Anyway,
Yeah, I didn't think about spelling that out. I mean, I figured.
But if there's no regulation, then he doesn't have any grounds.
Well, he'd say that we have a ordinance.
Yeah, we have it.
Yeah, I thought they don't, most of these things, I mean, they have some discretion to enforce it or not.
Yeah, I think there's some discretion in there too.
I think Susan's trying to define willful clearly as the fact you were given a warning, so now you're willful.
She's trying to get an objective definition of willfulness.
If you
I
don't
think is
abate
what
the
she's-
noise after receiving a warning, it therefore becomes willful and you are involved.
In other words, instead of having to get into that person's head to figure out what they exactly intended or didn't intend to do, we're saying, after a warning, if you do this, then we're going to consider you to have done this.
And then how would you deal with
Yeah.
2 calls in 24 hours and then not, or you warn them today and 9 months later you call that again?
And that, I think you've got
You
potential
have to
problems.
define that,
Yeah.
or
I think you've got potential problems. I mean, for any time you make a rule, there's going to be a person, if they're intent on trying to circumvent it, will find a creative way, and they're resourceful, and they'll find a way to circumvent it.
And that's one thing that the sheriff told us also, is when we do get our heads together with this, is to make sure that we have a district attorney that's agreeable with that.
Oh, absolutely. Yeah, I think you'd be making a real big mistake to spend a lot of time putting together the perfect ordinance, and then the district attorney looks at it and says, I'm not going to prosecute this.
well, I'm in favor of a warning system, but I was thinking the sheriff already had this, I wouldn't think about putting an ordinance. But if that solves the problem.
I think what Susan, and you correct me if I put words in your mouth, I think what she is saying is she might be a little bit concerned about how is it that you prove that willfulness or that maliciousness. And what she's saying is she'd like to see some language in there that would basically use a warning mechanism to help us define subsequent conduct to the warning as either being willful or malicious. In other words, it could continue after that.
Because earlier you said that somebody could say, even though they received the warning, they didn't think their noise was excessive, and so therefore they continued, you know.
But I think you could,
If the definition is, well, if you continue, then that's willful disturbance.
I guess ultimately, for those that are wanting to make sure that we only prosecute folks that have maliciousness or willful intent, leaving it as it is probably the best thing to do. Or either alternatively substitute the word willful with malicious, something malicious, one of the two. On the other hand, if there may be some of you that want a more objective standard than having to be challenged with getting into someone's head and proving whether they were malicious or whether they were willfully doing something. There are ways of doing that. I think ultimately, though, if the commissioners, if you believe your task from the commissioners is to do this to where we're only prosecuting people who are willfully doing this or maliciously doing this, then I would stick to that as close as you can. Now, the only point that I'm making is and I think we can probably all agree that whether someone is willfully doing something or maliciously doing something, the noise could be under such circumstances and so loud that we would probably all agree it needs to be stopped, whether it's being done maliciously or willfully. I think we can all think of an example of that. And that's my concern when I say putting those terms in, willfully and maliciously.
For this example, let's say the lady's been coming, the guy's been playing loud music and beating on cars and yelling and cranking his truck. Let's say he stops all that. If we would have something with malicious, let's say he decides to start just having a party every night. He's just having a good time. Is that malicious? I think you could.
I think it's going to be a hard sell to
And he just being, so then why is being loud? I'm not being malicious. I'm just being loud, but I'm not being malicious. So
and that's the problem.
In a sense, then you would, the ladies be coming, we're trying to fix our problem. They potentially have a loophole, and we have to fix their problem. We still got to continue the problem, and we have to come back and
Well, that's where if you don't abate the noise after a warning.
if you do that was for malicious. If you do the willful, like you say, I think you'll be. I think that was pretty rock solid with the warning tied in with the warning with the willful. I'm ready to shoot for the malicious. I think that'd be a way. So that's just an example of the problem.
I think malicious is even a heightened standard above willful.
And also you got the time frame that's going to be involved in that, and also the discretion of the sheriff's department officer that's out there investigating the complaint.
Well, you're hopefully going to do discretionary aspect of it, unless you got a sound meter or something like that. I don't think we're going to get into that. I wouldn't.
Well, I would have to study the use of equipment to measure.
I think you got.
I mean, because there are things that make a lot of noise that are completely legitimate, and that things that were needed.
Even spending time on that.
Well,
you kind of get the idea. I think we're all going to help with type of so people have heard about it. The worst one's probably the one that you've heard about already. And how do you do that without making this burdensome?
Well, let's go back to the definition again of loud, unnecessary, disturbing noise. And it basically says it's any noise which, because of its volume, level, duration, and or character, annoys, disturbs, injures, or endangers the comfort, health, peace, and safety of reasonable persons of ordinary sensibilities in the county. That's a shorthand statement. Basically, what we're saying is if this is a community standard, it is going to have to be so bad that it would violate community standard. Okay? Somebody having a cookout and maybe talking a little too loud or whatnot, that's probably not going to violate this, because community standards is that happens. But if it goes all night long after somebody said something about it, then I think community standards are that if it's really loud and offensive and long duration, and it's going to the middle of the night, most of us are gonna probably agree that that's a problem.
Just kind of want to go around the table and see where everyone's at with what we've done so far. Justin?
I like what you've got here with Chester's changes, and I like adding what the system talking about with the warning system tied in with the willful. I think that makes that pretty solid.
I think there's some parts of both of these revisions that are good. I see the need to address the malicious, that that's the word that needs to be addressed. And I don't know what the board is, but if they will see that in that, then we understand what the potential liabilities of that would be. One concern that I have is relative to the time.
Bill? You don't want necessarily willful, but you want the malicious.
I want to take care of that handful of people and go.
Do you feel like with the warning system and the willful, that goes too far, or?
I know it would be on a case-by-case basis, but the warning system, I think, could possibly create some problems too. I mean, say you're not doing anything that's particularly loud, but your neighbor doesn't particularly like you, and they call you in and say, well, I am outside washing the car,
Could I see that?
and I am making noise. And so they call you in, and the sheriff shows up, and he's like, okay, you are making some noise, I'm here. And then 20 minutes later, you're still washing the car because you need to quit washing the car. You know, you've not done anything wrong to your standards, but to her standards, or their standards, yes, you have done something wrong, and then you're in violation. So, you know, just like he was saying. So, yes, in probably 99% of the chances, that would solve the problem, but I still, with the malicious. I don't think we're going to create anything that's going to solve every problem. And
I agree.
think whatever we create is going to solve even the problems that we've seen, but I think it would be a good step forward.
Susan?
I like the idea of willful being included and with the warning system. I certainly don't object to the term malicious also being included. And like Carl, I have some concerns about the hours. If we do focus solely on malicious and willful noise, I don't think it should be limited to nighttime, because if it's willful and malicious.
I would be inclined to agree with you, because I think the person who wants to be malicious can find a way around that real easy, can't they?
They're already finding a way around it, because most citizens, if the sheriff came and knocked on the door and checked your wooden box, they'd turn it down.
He's going to turn it down.
Yeah, turn it down to high volume or something, I think, and anyway, go ahead, I didn't mean
Well, I like them short and sweet to the point. My concern from here at Chester with using malicious is that I'm afraid if those 5 or 6 that we get, somebody's going to fight it and get acquitted because they did hire a good lawyer. And then maybe it's the majorities are still in the same position, maybe in a worse position now because they lost. But the word willful, I like for that, at least for that to be in there, because that way it doesn't
Not accidental things.
open it up and where, like you're concerned, John, that you're gonna go out and ride your motorcycle, that somebody's gonna call you in. One example I was thinking of while I was sitting here up the Highlands Road last spring in May, they had a biker rally up there. It lasted 3 days. Yeah, it disturbed us for a little while, but we don't have any laws prohibiting that. Now, if it'd gone on through the weekdays, it's Friday night, Saturday night, they were going on Sunday. Whereas now, if they were doing that, playing the band till 3 o'clock in the morning on Monday night, Tuesday night, and Wednesday night, folks trying to get up and go to work, then, yeah, we need to have something there to protect us. I have a problem with the time frame too, because you can be willful, or you can be malicious, and you can disturb and annoy and endanger folks all hours of the day.
Well, I kind of like the word malicious to understand Chester's concern. I'm not married to it. I mean, there may be somewhere we hadn't even thought of it. Bridges this together. I don't know what it is, but.
Well, we may be able to cure, whether we use malicious or whether we use willful, we may be able to cure it by defining it, exactly what we mean
Well, I'm
by
looking
that.
at whatever, you know, I think the spirited thing is what we need to be working.
Exactly. I think I'm starting to hear a consensus that we're not wanting to say, oh, gotcha, you know, not a gotcha. We don't want a gotcha.
I am concerned about the time issue, though. I think that's something we're gonna have to come to grips with, because we're gonna lose some of these activities that.
If you've got somebody acting maliciously, you've just invited them to
Oh, yeah.
walk right around your ordinance, I'm afraid.
I kind of agree with Carl and Bill and Susan, all of with everybody what they said at this point. We need to find a way to strengthen with the defining the word malicious or whatever it takes. And I haven't seen the paper that was given out last week, the one John's got yet. But in the time issue, I have a problem with that too, because it can go on day and night. But I don't think we need to stop people from activities like the biking and the motorbikes and the things of that. It's just a temporary thing. It needs to be a continuous to protect the people that are disturbing constantly, maliciously.
I think, understanding the problems with something like the word malicious, I think that heightened threshold gives a kind of a conservative approach to the ordinance, especially starting off. And I think the 24-hour, application is appropriate.
John?
What do you think, John?
Malicious disturbance. Malicious disturbance would be any kind of behavior with an intent to harm. That's the definition that I got today off of the computer when I pulled that up. And as I've said before, I'm all about malicious. I think the people that has come to this board and spoke to this board is a direct malicious act from their neighbor, because there has been an ongoing dispute with these two neighbors, and one's going to say, I'm going to show you, and I'm going to show you. Well, you know what? When you bring in a full-blown noise ordinance, this affects my life and everybody else in this county that actually controls things that never was a problem before, until somebody new comes in and somebody gets mad at you. And then the next thing you know, you're in violation. But I still believe that lady that come in here, there's no telling how many hours and hours and hours of noise problems from her neighbor could be used. Because this lady is recording this stuff. I mean, she's filming it, she's doing everything. She's inviting the media to come over there and listen to it. And to me, let's go with a simple ordinance, malicious, and then get that thing drawn up and tweak it, add definitions. What is malicious? What is willfully? And put the definitions there. Put the time frame. Forget about the time frame. I agree 100%. If it's a malicious act, it could be 9 o'clock tonight, today, 9 o'clock tonight. If it's a malicious act, then it should be. I was just saying what the sheriff said. The sheriff said, if you do it, just focus on nighttime. That's just what the sheriff said. I could care less. If it's, like I said, if it's a malicious act, let's do it 24/7. But I still think that there's a lot of stuff in this noise ordinance, the nuisance ordinance, that is going to affect everybody in this county that is not really, that's not the problem. We don't have any problems. We got 6 or 10 people that's got a problem, let's protect them.
Okay, so the time thing, is there a consensus, 24 hours in lieu of 11 to 7?
If it's malicious.
You have a consensus for that?
You know, I think something we gotta think about, you know, I'm sympathetic to the story about the speakers on property lines and all that, and that needs to be regulated 24/7. There are some things that we probably heard about that, you know, the guy were beating on the side of the car before, or whatever we heard there a week or so ago. You know, I can let that go. I don't want to disturb their sleep, you know, but I don't know if we can do it that way. I think it's got to be 24 hours a day, or it's got to be 11 to 7, or it's got to be something, you know. So, I mean, I put different degrees of.
That's where the discretion of the laws would come into play too. It seems like if it didn't seem like an unreasonable noise for the daytime, then maybe we would issue a citation.
Can I throw something out there?
Absolutely.
John brought up the word there when he said, and you were just talking, intentional, as opposed to malicious or willful. That kind of merged the two together, because I think, like Chester said, malicious is, we're going to try to get around that. We're looking at those 10 people in the county right now who are doing it. Mark pulled up the definition of intentional right here. Deliberate, calculated, conscious, intended, planned, meant, study, knowing, willful, purposeful, purposive, done on purpose, premeditated, pre-planned, preconceived.
But that's also in the definition of malicious disturbance would be any kind of behavior with an intent to harm.
Well, that's what I'm saying.
Exactly.
But I think what we may do, we can probably talk about this all afternoon. Probably the best thing for us to do is if the idea was you wanted it to be intentional or malicious or willful, is settle on one of those words and then let's define it in a way that we can all agree on. And we define it instead of, I mean, you ask 15 lawyers what intent means and you get 15 different answers. But if you defined it one way, that is the answer. That is the definition. And I think this board's probably pretty close to being able to agree on a definition of what it is that you want to regulate. I'm hearing that you don't want a gotcha ordinance where somebody could be prosecuted for an accident or.
Did you ask this one?
Actually, I think what Matt has given you is close to it. There's a little tweaking to be done on it, but it is really probably a whole lot closer than you think it is.
Do you feel like you're too tweaking a little on that?
I think we're close.
What else do you need to be able to?
We mentioned
Well,
this.
we can decide if we want it malicious or willful.
I do think
That's a decision the board needs to make. 'Cause I think.
I mean, you can certainly have willful acts that are not malicious. I mean, I willfully picked this cell phone up. Or I willfully knocked it off the table. Or I could just be over here fumbling around and I could have accidentally knocked it off the table.
But we're not, the ones we've heard about that we're sympathetic to are not the ones that knock the phone off the table. They're the ones that threw it off or not, you know.
But intentionally covers both of them.
It does.
And that's a good purpose.
You see?
What if Matt and Chester tried to, I mean, you all first talk.
We can do it if y'all agree on it.
I think if the intent is that you're wanting to only regulate bad-hearted activity, then that word malicious is appropriate, and we can define it to maybe go a little beyond what we normally think of malicious, to maybe include a little bit more.
If it would include, I mean, I do think that people, yeah, there's a chance that, you know, Bill's example of somebody washing the car and somebody calling back, that's still not fair to prosecute them for it. But I mean, generally, I think receiving a warning and continuing with a loud noise Yeah, that's why I like the willful. Again, maybe it's not malicious, but it's willful if you've been told you're being too
Well,
loud.
then perhaps maybe we take the word willful and define it in a way where it's clear that we mean something pretty doggone close to malicious.
Yeah.
Is that something like that works?
Can we not define malicious to basically say that same
Oh,
thing?
my gosh.
Well, you can do it either way. I mean, I don't, it's, that, we're at semantics at this point.
Another thing I'd like to see is the title of the ordinance to be very specific and narrow so that 5 years from now, somebody will come back and say, oh, we've got a noise ordinance, let's load it back up. Put something, I mean, like the nuisance ordinance, I mean, that could be smell as far as
Maybe
just
it's a
that
nuisance
title.
noise.
Noise or something
Noise
like that.
nuisance.
Something
Well,
defined.
Now, one thing I really hate is for you all to get together and decide to go with willful and intentional or malicious, and then next week we talk for 2 more hours about willful, malicious,
The
or intentional.
definition
That
of
would
it.
be painful.
No, we need to decide if we're going to be willful or malicious and get that.
I make a motion, we go with malicious.
I want to ask a question first. Would you be able to write a willful definition that included the intent of harm? Would that fly? Because that seems to be giving willful more of a definition.
That's one of the definitions.
Okay.
But isn't that what,
I think that's essentially what this is saying, is that willfully make or continue to cause. To me, that's his intent. Yeah.
but that goes right back to this definition of malicious disturbance.
Well, why don't we take a
Intent
vote
to
on
harm.
willful?
Yeah, we
I
have.
made a motion.
We have a motion for malicious and a second. Is there any other discussion on using the word malicious?
I don't think it matters whether you use malicious or willful, as long as you settle on what you mean by that term.
But it would be very
But
nice.
if you look
to
in
decide
20
which
different
one.
dictionaries, you're going to get 20 different definitions of each of those.
Well, right, well, at this time, though, we're all focusing on the people that's come here with a complaint that is a direct complaint from their neighbor that is a malicious act with the intent to disturb them to the point that they can't sleep. So,
It's also a willful act.
right,
And the question is it important, if they've done that and it was willful, is it important to also prove that they did it with an ill heart?
but that's what I asked earlier.
If they willfully did it in any event, is it important to show an ill heart?
Can you not do what I asked Ms. Susan earlier? A willfully, maliciously noise ordinance. Can you not put both of those as a heading of it and define each one of them, so now you've got both?
I think it would be redundant.
Well, if it just says noise ordinance, and then in the definition, it talks about willful or malicious.
Okay, we have a vote on the floor to use the word malicious in lieu of willful. Is that what the motion's
I
for?
think that's a fair statement of it.
Can I
And a
say
second.
something? Can you not use just malicious, willful intent?
I think we need to take a vote on if we're going to use the word malicious at all in the document.
Is that what the motion is, Sheriff?
My understanding is to use the word malicious to describe.
In lieu of willful, I think is the intent.
We have a motion and a second.
Questions?
Further discussion. From a legal perspective, what's your recommendation? The worst thing we can do is pass something that's going to cost the prosecutor or the sheriff or anybody any kind of problem. So I think we need to iron that out first.
I think there are going to be different kinds of cases. I think there are going to be the proverbial slam dunk cases where if you use the word malicious, it ain't going to make one bit of difference. The guy who sets the speakers out on the,
That's the slam.
I mean, I think I don't practice criminal law, but I think I can prove that case beyond a reasonable doubt. Yet on the other hand, if you've got somebody that has bad intent in their heart and wants to be a thorn in their neighbor's side, they're going to be able to do things that don't look like they're so malicious, but be equally objectionable. And that is where using the word willful, it seems to me, might be better. At least that way we're not having, I mean, if somebody says, well, gosh, I didn't know those speakers I set right next to my house and turned up as loud as I could and left for 6 weeks, was going to be a problem to my neighbor. Your prosecutor is going to have to prove, yeah, you did. You did, and not only did you, but you did it because of some sort of bad feelings or some sort of ill heart towards these people.
But would the sheriff going over there and issuing a warning to these people that is disturbing their neighbors, is that not teeth for the court to say?
That's one problem with building in a warning system, because there ain't nobody to warn in that situation. They're not.
They went to work for 6 days or 6
Yeah.
weeks.
Well, sheriff fell on the power line.
It's called to vote.
Yeah, on the other hand, if you use the word willfully, now think about this. If you use the word willfully, I mean, every one of us in this room probably agrees that the guy who moved them back from the lot line 50 feet in to right next to his house, but did exactly the same thing otherwise, he's probably acting out of malicious intent, probably.
Or willful, or whatever.
But definitely willful, okay? Definitely willful. I think we could agree on that. And that's where the word willful might be a more appropriate word.
Repeat the same goal.
Okay, so it's called to a vote. We're going to use the word malicious. All in favor of using the word malicious, raise the hands. Opposed? So we're going to abandon the word malicious from here on out.
Completely.
It's not going to be in the ordinance.
So now we need to decide what we are going to use.
What we're going to use.
Make a motion that we use the word willful.
What I'm hearing from this body is that the body feels that its marching orders are that you are to use some sort of standard that avoid the situation where somebody could be neglectful and be in violation of this. And the word that comes to my mind first would be willful or intentional.
Mr. Chair, it might be appropriate that we agree on a definition of willful that might satisfy, partially satisfy things there.
Yeah, I think you could probably define the word willful to,
Which you rather
amp it up. a little bit.
suggested definition for local.
Well, I think that's something that.
I had the motion that Matt worked with Chester and develop a word, a definition of willful that is very similar to what we perceive the word to be malicious, so that we can use that incorporates exactly.
But it would include the fact that there's comprehension that this is causing disturbance. I mean, you've been told, you've been warned, whatever.
I think
Comprehension.
you grasp what we're trying to
I
achieve.
think I do, yeah, I think we can get there, and does Matt have all of your email addresses? What I would propose is that we take a crack at defining that, and then we shoot it to all of you by email, and each of you just respond back to Matt or me, as the case may
Mr.
be,
Flores
with your
told us
thoughts.
we can't do that.
What?
He said that we cannot respond to emails.
Who did?
Commissioner Flores.
So you should discuss.
You could respond to Chester.
Oh, you could-
You can,
Oh, we could
yeah.
respond?
Yeah, you can
Yeah.
email Matt,
But
you
you
can
can't
email
email
me, and
Okay.
vice versa, all you want to, not have a problem. If the problem is where y'all get into an exchange among yourselves.
So we would only respond to Matt rather than to
Yeah.
respond to all.
So that would respond back, we would have to dialogue with Matt.
Our
Man
intent,
can take these 10 pieces or 11 and mold it into whatever.
My concern is that we're taking the word away from Chester, and he may come up with a better word than malicious or willful. Because there's
Well,
intentional.
I think we can use potato, if we define potato as whatever we're
I
going to
mean,
define the word as.
personally, I'm open to whatever. If you all come up with a better word, that's fine.
yeah,
That's my opinion.
Yeah, you're right.
but I'm hearing loud and clear that we want to try to address those situations where we think people have a pretty good idea of the effects of their conduct.
So we don't need a motion that it's gonna be willful. We just need,
I think if you're gonna do a motion, I think it would be appropriate to understand what
yeah.
what the word is and what you
Yeah.
vote.
Get the meaning and everything down. Because this is the same old thing that we've seen for many years, my entire life, I'm probably older than about these years, is the fact that the neighbor would build out up to the property line. Another neighbor didn't like where he built, so they built a hog lot in the backyard. That's gone on as far back as I can remember, and that's almost the same thing they're doing now. Malicious, willful, intent to pay back the bill on the property line.
Yeah, you're right.
If you want to take a cautious approach of not over-regulating, you can certainly do what you were suggesting is you can go with what you pretty well know you're trying to address. And if practice proves that it's not enough, then you can add to it. If practice proves that it's working, then you leave it the way it is. I mean, the fact that you pass an ordinance doesn't mean that it has to stay that way forever.
Go ahead, John.
No, I was just gonna say, get one started and see how it works, and always come back and amend if necessary, right?
I do think we should consider having noise in the title of the ordinance, because nuisance does sound like it could be in the backyard or barking, you know, or any other kind of nuisance.
I could be wrong about this, but I think the thought of using the term nuisance, to me, nuisance is something that, if there is a nuisance out there, what does that conjure up in your mind? There's a problem. There's
But
a
it's not
problem.
necessarily noise.
You're right. But I think the point though is I think those that are talking about regulating this area only want to regulate a problem, a nuisance, so, a noise that is so wrong and offensive that it rises to the level of being a nuisance. I
But
think that's the
you
intent.
have nuisance in there, it also includes
Could you say
something
nuisance
that's audible
noise?
nuisance or something.
Well, and that's essentially where I was trying to go a little bit when we talked about purpose. We could cite it as in 16001, it talks about result from loud, unnecessary, disturbing noise. That was just a little tweak to try to blend the concept of noise and nuisance together. I think the commissioners are pretty clear that they do not want to regulate noise if it is not to the level of being a nuisance. That,
Yeah, I would say that's fair. Before we use the word noise,
yeah,
that-
noise can mean a lot of different things. I mean, or me yelling at the top of my lungs is a noise. Covers a large area.
Before we finish discussion on this, does a member of the media have something she wants to say?
I just wanted to bring a different perspective, since this is the first time I've been to a meeting. But as far as like the malicious goes, for example, if you put the speakers on the edge of your lawn and you ask that person was it malicious or not, they're not going to say, yes, I did that intentionally, especially if it's going to court. They could easily say something like they were going to be gone for 6 days, so they put the music up to deter people from coming to their house. And it's not malicious, but it was intentional. They did create intentional noise. And so proving the malicious that's just disprove that. And then as far as the motorcycle goes, when you said you were afraid they would regulate that, well, that's unnecessary noise. That's not unnecessary. To start the motorcycle, that's a necessary noise. And as far as the motorcycle event that was loud, that would be protected because of the economic value of that event. So each example that you gave were either covered or disproved with the other points of the ordinance, which I think kind of got lost in the debate.
Thank you. Okay, we have Matt's going to get Winchester. We're going to get a definition out. They're going to work on getting the same rewritten and have it to us at our next meeting. Our next regular meeting. Well, we're just going to do a special meeting.
That's actually a continuation.
I don't know if it's actually been set yet. I think they targeted for, was it the 19th?
17th, 6 o'clock, it has.
I don't know that they've actually set it. If it's been set, I don't think it's gotten to me.
Okay, so the 17th is the meeting with the commissioners.
It would be great if we had this done.
Our next meeting will be tonight.
Our next regular meeting will be the 19th. So you guys want to try to get this thing finished before we meet with them again?
He's there for that.
As long as we don't define anything.
How much time do you need, Matt? Chester?
2 weeks.
Pick the 10th. We're going to sit here and finish it on the 10th.
Well, I mean, I think we'll all know, we'll see the definition prior to that, and then we'll go.
Does the 9th work for? The 10th works for everyone.
We follow Chester.
That's a second Tuesday.
It's only 2 weeks.
I don't think we've got an awful lot more work to do. I need to do just a bring up on some cases. Nat has carried forward a number of principles that I think are probably going to be fine from a legal standpoint to go in this, based on some case law that I'm familiar with. I do need to go back and look at those cases and make sure any changes to the law in that area. As far as the actual changes, Matt and I had a conversation this afternoon that worked through most of my concerns pretty quickly. And I think now that we've got guidance from the board that you really want to focus on something, that is very clearly intentional kind of situation, we'll work on getting that language in there to where hopefully it's more clear the type of thing that we're asking. And I think Matt can probably also help me identify the specific problems that we have history of, and we'll tailor those in to this ordinance as well, as examples of the types of things that we're not an exclusive list, but as examples of the types of things we're trying to get at.
Okay, so that'll be February 10th at 4 o'clock. Location to be determined.
I won't be here then, we'll do it next week.
I'm not going to have time to do it when next week. Calendar's pretty full.
So if you could send your thoughts to Matt after he gets the information to you, we'll be sure to share.
The time issue, are we okay with the idea that, what do we use the word willful or malicious or whatever, that I think it's going to be more of an issue
think we got to somehow deal with that. I agree.
I think we will. I guess I'm optimistic about that. What I'm hearing is, as long as we communicate the intent of what you're trying to do here, that we'll get there. And what the way I propose to do that is for Matt and I to work on that particular part of it first and get it circulated to each board member with an invitation to please critique it and give us suggestions if it needs to be changed.
Right, so just to be clear, we can critique back to you or Matt, and you can take the critiques and mold them into.
Yeah, what we will do is we will attempt to address those concerns the best we can. Now, obviously, if we get one that says it must be white and the other one says it must be black, we're not going to be able to deal with that. We're going to have to do with it the best you can, and whoever wrote those comments will realize we're doing the best we can.
Well, we can still talk about it.
Absolutely. Just because it's written one way or the other doesn't mean that's the final word.
Just because Chester doesn't incorporate my comments doesn't mean that I still won't have my input again.
Absolutely.
Okay. Also, we have a meeting on the 17th with the commissioners at 6:30. Oh, 6. No, I'll be there at some point. If we could get some ideas together of some planning that the board would like to look at doing in the future when we're done with this subject, if you could just kind of put those ideas together and send them to Matt so that we could share that.
And likewise, I would encourage you to put back out on the table a request from the board of things they would like for you to look at. They will get a chance to maybe talk about that before that 17th meeting. It might make your meeting more productive.
Okay.
So this will be a continuation meeting again? That's a question unanswered.
It would be,
Yes. Just need a motion.
So we need a motion to continue.
So recess,
give
give them time and place.
recess until the 10th at 4 o'clock. Location will be determined.
Got a name and location.
Well,
We will go back to A and B if it's open. If it's not, I'll reschedule.
it's open today. I've already been up there, looked around.
Yeah.
That's a board meeting.
Oh, okay, they just got through.
Where is that?
Health board.
The health board at the
Health department. That's where we usually meet.
lakeside going.
Well, you all work that out, I guess.
I'll second.
Just for the-
What day is that? The 10th. Y'all want me to come in there?
Yes.
I think if we're going to try to get this knocked out, I think we need you to be there. And that's the second Tuesday.
At 4 p.m. As long as I'm out of here by about 5:30.
Okay?
Thank you, sir.
Thank y'all.
Thank you for your time.
Thank y'all for your time. Obviously, you're taking this really seriously. I've heard a lot of really good thoughts, and I think the thing that probably impressed me the most is I heard with regularity about how you're desiring to do exactly what the Board of Commissioners have asked you to do, and tailor this to the things that they're concerned about. I think that's to be very much admired.
So we're here to benefit.
Y'all want me to see if I can get